Welcome back, everyone. Today is Monday, February the 3rd, 2025. My name is John Collins, your host for another edition of Crime in the Courtroom. And I'm really looking forward to sharing today's topic with you because it's going to allow us to hopefully debunk some misconceptions that exist in our criminal justice system about physical evidence and expert testimony related to physical evidence. And it's also a good day to be discussing this particular topic for two reasons. Because today we kick off our first online advanced expert witnessing workshop of 2025. Our students have already gotten started, and so this is always a fun week for me. But also, the topic for today allows me to build on some of the issues that I raised in my tribute to John Murdoch last week, who passed away very recently. These were issues that were very much important to him, and I really appreciate all of the kind emails and text messages that I received after that update last week. So for those of you that reached out, I just wanted to express my gratitude. I really appreciated it. A quick housekeeping or programmatic item, I should say. I also want to mention here that up to this point, as we've transitioned into our new Crime in the Courtroom podcast format, I'm doing some monologuing without guests as a way to be somewhat cautious and deliberate in how we make that transition. But looking ahead, I am genuinely excited to be welcoming some really interesting guests that will be joining me on some upcoming episodes here in the very near future, and I promise that you won't want to miss that. So, on this first Monday of February 2025, what I would like to do today is to build on our last episode by discussing the subject of forensic science and forensic evidence more broadly. The opinions that certain professionals or commentators in our criminal justice system have of forensic science or forensic evidence, as we might expect, depends on what their responsibilities to our criminal justice system may tend to be, which is to say that their opinions of forensic science or forensic evidence depend on what they are trying to prove in an investigation or inside of the courtroom. In criminal litigation, there is often one party that is attempting to discredit or weaken forensic testimony, and the other party is trying to use it to prove something. So it finds value and utility in the forensic evidence and therefore wants to bolster its weight in the eyes of the jury or judge, if that applies. So in the United States, as it is in many countries, expert witnesses are not called by the court. They are called by, or I should say, they are not called by the judge or any administrator of the court. Expert witnesses are called by one of the competing parties in the case. And for that reason, an unfortunate part of being an expert witness in court is that you are viewed as playing for one of the teams that are competing against each other. You are either on the prosecution team or you're on the defense team, which means that if the testimony of an expert witness supports the prosecution's case, then the expert witness is regarded by the defense as the enemy, and vice versa. It's really important for us to keep this in mind. It's part of the culture of criminal justice in America. Now, it's interesting because up until I would say the early to mid 1990s, or around the time of the O.J. Simpson trial, our criminal justice system was very strongly oriented toward the prosecution of offenders and the punishment of those offenders for the crimes that they committed. So it was a cultural imperative. So criminal justice for the balance of our history here in the United States has really been strongly focused on and prioritized around catching bad people, bringing them to justice, administering due process, seeking a conviction, and then punishing the convict. And as we know, punishment in some cases can mean life in prison or even death. although death penalties are not nearly as common now as they were in the past. But who knows, that could change. So, to give you a bit of background on this, in 2019, I authored a textbook called Crime Lab Report, an anthology on forensic science in the era of criminal justice reform. And in Crime Lab Report, I wrote about these issues in quite a bit of depth for what I would describe as a more academic or scholarly audience. The book was published through academic press, and they tend to cater to a more scholarly audience. But more recently, which is why I'm discussing this with you today, I released the second edition of my third book, which was titled 50 Situations Awaiting Every Forensic Scientist, Professional Effectiveness Handbook. And I'm excited to say that this is an audiobook, which just became available. So it's in print and audio. One of the major changes in the second edition of 50 Situations is the inclusion of a new concluding chapter or closing chapter, and that is titled A Different Kind of Science. And the inspiration for this supplemental chapter was my own, or I should say, came from my own coaching clients in forensic science, as well as participants of my workshops and other folks who might reach out to me to ask a question or share a thought. And what seems to have been happening is that there is an entirely new generation of forensic scientists and even trial lawyers who do not remember the O.J. Simpson trial. They do not remember the very early years of the Innocence Movement, the Innocence Project, when there was a sustained and very well coordinated public relations attack and judicial attack on the credibility and integrity of forensic science by activists in the Innocence Movement. And now these forensic scientists and lawyers and whomever else may take an interest in forensic science, who are in the early years of their careers and are now asking questions about things they are hearing and reading in the public domain. The worst of those criticisms, of course, or at least I think is fair to say, is that flawed or invalid forensic evidence or flawed forensic testimony is leading the reasons for erroneous convictions, that it's a leading cause of erroneous convictions in the United States. So they are just now trying to make sense of things like the 2009 National Research Council report on trying to strengthen forensic science, the 2016 PCAST report, which was the President's Council of Advisors on Science and Technology under the President Obama's administration, and other official sources claiming that forensic science cannot be trusted and continues to do great harm to the fairness and integrity of our criminal justice system. If you happen to be a young forensic scientist, what a horrible thing to hear about this new profession that you've chosen. So this is serious. And because, quite candidly, 50 Situations was really in need of some updating, I wanted to address this issue for new forensic scientists, especially that are now learning about the Innocence Movement, its advocates, and their claims about forensic science. And I certainly did not want to, how would I say it? I didn't want to reflexively defend forensic science from an ideological standpoint or try to make it out to be better than it actually is. And I certainly didn't want to ignore problems or weaknesses that might exist or do exist, because all professions have them, including forensic science. So Let me read to you an excerpt from this new chapter in 50 Situations called A Different Kind of Science, and then I'll share some thoughts about it with you. So, quote, as you enter the profession of forensic science and begin the launch of your career, it is important for you to know that you are, in fact, joining a profession that is among the top preventers of erroneous convictions. Without you and your colleagues, many more injustices would occur. Don't ever forget that. So here's what we know about erroneous convictions and the role forensic science plays in these travesties of justice. When they happen, their causes are multifactorial, which is to say that a perfect storm of threats come together to create an unfair but plausible portrayal of an innocent defendant as being guilty. At the same time, mitigating conditions that would otherwise prevent these threats from harming the integrity of the judicial process are for some reason absent or compromised. Dr. John Gould at American University found in his own research on erroneous convictions that innocent defendants are most vulnerable when they are already known by the police, especially when there is an incorrect eyewitness account that implicates the defendant. Prosecutorial misconduct and incompetent defense representation might also conspire to produce erroneous convictions. But from my own research and deliberations on the causes of erroneous convictions, it's clear that something else is going on, something rarely factored into the equation. The evidence is clear that defendants who happen to be arrested and tried in overwhelmed criminal jurisdictions, these would be jurisdictions drowning in high case volumes with poor staffing and a scarcity of financial resources, are, without question, the most vulnerable to being erroneously convicted. Justice is impossible to deliver with an assembly line mentality. Justice requires caution, thoughtfulness, and attention to detail. When defendants are shuffled through a system like cattle and trials are held on shoestring budgets, the checks and balances that would otherwise prevent erroneous convictions become impaired. From there, all of the factors mentioned above become more of a threat, even to the point of catastrophe. Forensic science, with all its rigor and discipline, is a valuable mitigator of the chaos that enables erroneous convictions. So, why does forensic science then receive so much blame for judicial atrocities? Fortunately, it's a simple question with a simple answer, because forensic science is so popular. End quote. And from there, I go on to explain that forensic science tends to be a part of the criminal justice enterprise that gives people confidence. It does. Forensic science gives people confidence in the administration of justice. This means that to the degree that the general public knows or believes that science is used in the administration of justice, then they are going to have more confidence in it. But if you happen to be a criminal justice reform advocate, or activist, then the confidence of the public becomes a major problem for you. The public typically doesn't want to reform things that they are confident in. From a political perspective, it's pretty straightforward, I would say. So, as I wrote about in Crime Lab Report, as I said in a lot more detail, that is precisely why, for those of us who remember the all and out assault on forensic science by innocence activists, began, not coincidentally, just as forensic science was getting popular. When the Discovery Channel launched their new show, The New Detectives, and when CBS launched CSI, which became one of the most successful television dramas in history, these shows celebrated forensic science. And for very good reason. Forensic science is worth celebrating. And it also happens to be a really interesting topic for people. They're entertained by it. But to their credit, innocence activists wanted nothing to do with any celebration about forensic science. And in fact, they were quite troubled by it. And so they were demanding the opposite, that forensic science not be worshiped as perfect, but instead to be looked upon as potentially flawed, justifying more caution and scrutiny in how it's perceived. This was not something that we were prepared for amongst those of us working in forensic science, and that, my friends and colleagues, was our fault. And I would argue that as a profession, too many of us in forensic science had gotten a bit sassy and a bit overconfident to some degree. Yes, there was some great work being done in the 1990s with accreditation and quality assurance and the rise of DNA profiling. But we were not prepared to answer some of the very nuanced and foundational scientific questions about the work that we were doing. And so we couldn't defend ourselves. Historically, as forensic scientists, we learned how to stand firm in the face of vigorous legal challenges, particularly in the courtroom, but we had never really been tested with strong scientific challenges. And that was a classic case of what happens when people get a bit too arrogant and a bit too cocky in what they're doing. And that was us, generally speaking. And we paid a dear price for it, but we got better for it as well. Now, that being said, I want to address something here that I touched on in the chapter that I just quoted from, which is the accusation or concern that forensic science is not real science, meaning that it isn't based on the same degrees of academic inquiry or research that we see in things like biology, physics, chemistry, medicine, engineering, and so forth. What we might call the more classical sciences. To scientific researchers who have more academic sensibilities about them, forensic science often appears to them to be a family of homegrown pseudoscientific techniques and methods that arose not out of academia and not out of the same kinds of research intensive environments that we see in medicine, for example, but rather forensic science was thrown together hastily by cops. So, to these kinds of observers, forensic science is not real science, it's police science, with big, huge air quotes used to qualify the word science. Because, it's not really science. I mean, come on. Looking at scratches on bullets or ridges on fingers or bite marks on skin, give me a break. And people are actually convicted, sentenced, and sometimes even put to death because of this stuff. I mean, is there a such thing as having a PhD in bite marks or a master's degree in firearm identification or latent print identification? Who the heck do you think you are going into a courtroom with this garbage and using it to convict people and deprive them of their life or liberty based on this junk police wannabe science? You should all be ashamed of yourselves. How dare you? And so the criticism goes. There's way too much to unpack here in the limited amount of time that we have in a single episode, but it is important to recognize something here, which is that over the last 30 to 40 years, there were four specific areas of forensic practice that seemed to fuel the attacks on forensic science in the courtroom more than any other. And so they sort of created a legacy of discontent and confusion. And those four areas were human hair comparisons, blood serology, fire pattern interpretation, and bite mark evidence or bite mark comparisons. These were the forensic practices that innocence activists saw as being especially troublesome. The first two, in fact, are inherently problematic, even for the scientists that practice these disciplines, because they don't or didn't lend themselves to conclusive determinations. For example, with blood, back in the day prior to DNA, you could only say what type it was. However, you could, in fact, conclusively eliminate a person as being the contributor of a blood stain. So, a victim with one particular blood type isn't going to leave a stain in the trunk of a perpetrator's car that has a type, a different kind of type. That would be an elimination, or we would rule out that person or that source of that blood. In the same way, you might um, you might be able to say that this person could not have been the originator of let's say, a hair found on a bed sheet at the scene of a criminal sexual assault. Hairs and blood decades ago were great for ruling people out or ruling sources out, but not for identifying people conclusively. There were limits. So this created confusion at times. And if you were testifying in court, if you use the wrong words, you could easily worsen that confusion. And to be candid here, this happens to be a very legitimate criticism of hair comparison examiners back in the day, because they used to use the term match to describe hairs that had similar physical or optical properties, even though they couldn't identify the hairs as coming from the same person. It would be kind of like having it'd be kind of like having two red apples that are about the same size, the same weight, the same color, and generally about the same shape and size, and so you say that they match. But in fact, they're different apples, and they are not going to be identical at every possible level of analysis. So how can you say that they match? That's a legitimate question. Now, with regards to the comparison of hairs or serology, there is absolutely nothing we should point out here that would prevent a defense attorney of even modest competence from asking, so what does match mean? And then the scientist would be responsible for explaining the limitations of the work and what that word means, which they usually did anyway to make sure their conclusions weren't misconstrued. They don't want to mislead juries, at least the vast majority don't. But again, words matter, and they should not be manipulated to give an advantage to one party in a trial over another. Even hairs that were described as matching might have had differences about them on some level, including potentially their mitochondrial DNA structure. And so that term is not used anymore, and that's good. And good for justice reform advocates who held forensic laboratories and forensic practitioners in these particular areas of practice accountable for this. Another very interesting forensic method that has undergone significant refinement over the last few decades was fire pattern interpretation, which was the practice of observing what we might describe as meandering burn patterns on the floor of a fire scene that were often interpreted as being indicative of an accelerant that was poured on the floor and meandered in different spots. But as we now understand, certain materials, such as carpeting, can create confounding evidence that looks very similar to an accelerant pour, even though there isn't one, or there might not be one. So that's another forensic technique that has been subjected to a lot of scientific scrutiny in recent decades. But the last forensic method I mentioned was bite mark comparison, or forensic odontology, as it's often called. And I want to emphasize a few things with regard to bite marks because they allow for a better and broader understanding of some of these unique challenges that forensic science, a different kind of science, present to our criminal justice system. So it's useful for us as a point of study or inquiry for our purposes here. The reason that forensic science is a very different kind of science is because it's comprised of various methodologies that study or investigate two things that few other scientific enterprises will have any reason whatsoever to even attempt to investigate, which are randomness and uniqueness. Randomness and the uniqueness that results from randomness are the basis of much of forensic science. For example, we might be talking about the randomness and uniqueness, as we've said already, of the patterns of scratches on the surfaces of bullets left by the corresponding patterns of microscopic imperfections in the barrels of the guns that fired them. We might be talking about the randomness and uniqueness of the patterns of friction ridges on the pads of human fingers or palms or toes. The randomness and uniqueness of the patterns of wear and tear that build up on the bottoms of your shoes or boots, which could then appear in a footprint and used to identify your shoes as having walked on the grounds of a crime scene if you happen to be there. Randomness and uniqueness of the, let's say, molecular arrangements on the DNA strand. Randomness and uniqueness of the jagged edges of a piece of broken glass from a side rear view mirror at a hit and run scene that could be identified to the car that killed the victim at the scene. Forensic science, more so than few other scientific or technical enterprises, seeks to observe random phenomena and then make determinations about the uniqueness of those phenomena. That's where the expertise lies, and that's what we're trained in. That is what much of forensic science is. If I have a suspect in possession of a firearm, for example, and the barrel of that firearm repeatedly creates a unique and random pattern of scratches that also appear on the autopsy bullet from a murder victim, that suspect now has some really difficult questions to answer. There is there is no other scientific or technical enterprise that seeks to conduct these kinds of analyses or make these kinds of determinations. I mean, think about this for a second. Who else was going to determine if Lee Harvey Oswald's firearm was used to kill President Kennedy? Who else? A biologist at the University of Texas? Uh, a physicist at MIT? A chemist at the University of Michigan? No. It was a determination made by educated, qualified individuals who specialize in examining, comparing, and drawing conclusions about that particular kind of random pattern on bullets. People who were trained and equipped to do that kind of work. And of course, just as another example, it was a different kind of professional who identified Oswald's fingerprints or palm prints on the rifle that was used. Now, with regards to these, what are called pattern identification sciences, as they're often called, which happen to bear the greatest brunt of the criticisms. Here is where a grave mistake continues to be made, not only by critics of these practices, but also by the forensic scientists themselves that practice these disciplines. And that mistake is thinking that there is, in fact, no larger body of scientific or academic inquiry in which these kinds of analyses are conducted or studied, right? DNA has biology. Drug chemistry has chemistry. But what about these pattern comparison methods that we've mentioned here? It's not biology, it's not in chemistry, it's not in physics. So what is it? Is there any overarching scientific body that would or could provide a suitable intellectual or scientific home for these disciplines? And the answer happens to be yes. It is a branch of science, a well-established branch of science and mathematics that's called stochastics. And I've written about this before. I've studied it at length. I've spoken to people who specialize in stochastics. And stochastics happens to often be described colloquially as the science or the study of randomness. Stochastics is a specialized and focused area of scientific and mathematical inquiry that contends with the problems of randomness. But its rise as a field of study later than the rise of forensic science was the problem. So forensic science never really had a chance to make it a home, if you will, in that particular realm of scientific study. But it does exist, and forensic science, in my judgment, would do very well for itself to figure out a way to make its home there. It's not going to happen overnight. But there is no other home for these often heavily criticized forensic disciplines to have, which is why they are so exposed to these criticisms and they have such a difficult time clawing their way out of them. For example, when you look at the wounds on the skin of a victim of a criminal sexual assault, let's say that were left by a perpetrator through the act of biting the skin of the victim. It could be on the victim's shoulder, on the victim's neck, on the victim's breast. So what is left behind on the skin that we can see and what we might describe as a bite mark is actually a pattern of impressions that correspond to the patterns of the surfaces of the teeth that left them there. The way that those teeth grow and arrange themselves in a perpetrator's mouth during infancy and maybe over time, you know, one tooth being angled slightly this way, one tooth being turned slightly this way, one tooth being a bit larger than the ones next to it, all of these things in their totality as a pattern are random phenomena. Now that some or much of that randomness uh, might go away as the result of, let's say, wearing braces. And perhaps you would not be able to identify the perpetrator from a bite mark. But you could potentially if those patterns are pronounced enough and with irregularities and contours that lend themselves to being observed and compared to bite marks that might later be collected directly from the biter under controlled conditions and under the supervision of forensic experts or law enforcement. Now, it is very easy to arbitrarily dismiss bite mark comparisons as junk science, as many critics often do. The skin is too malleable. The patterns are too faint or too blurred to make a conclusive determination. And these very well may be the case. These claims very well may be true in certain instances, but perhaps not in every instance. This means that the endeavor to conduct the comparison of bite mark patterns is entirely legitimate, and it may result in a scientifically justified identification of the biter, or it may rule out a candidate or a perpetrator, or it may be inconclusive. You just can't do anything with it. That's all perfectly acceptable. But the act of making the comparison is entirely legitimate, and to say that it has no scientific value in any conceivable situation is just plain irresponsible. Very irresponsible. I I guess it wouldn't hurt to be a little controversial as we do this. I might be inclined to agree from a semantic standpoint that bite mark comparisons, that firearm bullet comparisons, and latent print comparisons, to name a few, are not in and of themselves areas of true or complete scientific inquiry, and that it might be inappropriate to describe them as sciences. I think you can make a very strong, credible argument for that. Because what they are applications of methodologies that are looking to take advantage of something that is bigger than themselves, and that is stochastic phenomena. And so it is stochastics that is, in fact, the originating scientific home base for these forensic practices. Bullets, the tips of fingers, or the surfaces of teeth, the underside or the outsole of your shoe, have stochastic irregularities and contours. And yes, the study of stochastic phenomenon is an entirely legitimate, well-established area of scientific and mathematic and statistical inquiry. This is why forensic science is a different kind of science. It is because forensic science is a historically rare branch of scientific inquiry that predates its academic origins or justifications. It's kind of like a child being born before its parents, in a way of speaking. In reality, stochastics has probably been around back since about the 17th century when probability theory was really coming of age. But actual stochastic analysis in the modern area really didn't establish itself until about midway through the 1900s, and then more recently during the era of computing, because only computers could handle the complexity of these randomness models. For example, in economics, random fluctuations in stock prices are studied to understand investment risk and to predict economic activity or economic volatility. Gaming and gambling are also areas that involve stochastic principles and the study of stochastic fluctuations. They're random. The shuffling of cards is random. Now, there's an interesting matter of again, nomenclature here that I think will be helpful to people that are in forensic science, particularly in these pattern identification disciplines, which I believe we should start calling forensic stochastic patterns, by the way. And those two terms in stochastics that are used are called, well, first, stochastic, which is another way of describing random, and the other is deterministic, which means intentional. And so it's really interesting because in forensic science, because it predates the modern applications of stochastics, we traditionally developed and used different terms. We use the terms class characteristics and individual characteristics, but they mean the same thing. Individual is stochastic, class is deterministic. So I find it really fascinating that even though, and this is a credit, by the way, to our founders in the profession of forensic science, that they were adhering to terminology and methodologies that were in alignment with the field of stochastics, even though they may not have ever heard of the word stochastics or knew what it was, as I did not during my forensic laboratory practitioner years. So the next time you hear that forensic science is junk science or that forensic science is a leading cause of erroneous convictions. All I would suggest is that when we look at the facts, good things happen, as they often do. And what we find when we look at the facts is that forensic science, without question, is a leading preventer of erroneous convictions, and it is to be appreciated and celebrated for what it does to preserve the accuracy and the fairness of our criminal justice system. At the same time, there is a need in forensic science for some of its members to make new and proper connections to their scientific home, which is the study of randomness, which is called stochastics. And I certainly I plan to continue to make it a professional goal for me to help make forensic science professionals more aware of what stochastics is and why it will be so important to them in the decades to come. To embrace forensic science, not as its own scientific enterprise, but as a specialized branches of stochastics. And when this happens, there will be new and exciting opportunities for research and collaboration where they've perhaps never existed before. So, in closing, this was a much more technical and perhaps heady episode than we would normally do here, but there's a good reason for that. Forensic science continues to be in very high demand, and it plays a vital role in our administration of justice. And at the same time, it is now heavily scrutinized, and there is a lot of rhetoric that's been flying around over the last 20 to 30 years about what forensic science is and what it should be. And look, some criticisms are fair. There's no doubt about it. But many are not. But when we look again at the facts, things start to make a lot more sense, and we will find our top priority should be to make sure that we have honest, ethical, and responsible professionals doing this kind of work. Because when we do, forensic science, far more often than not, is an occupation that is worthy of trust and respect. So for you forensic practitioners out there, the kind of professional you are willing to be, and the kind of professional I am willing to be, is ultimately what will determine the kind of profession that forensic science is and will become. Thanks for listening, everyone. It was great to see you again. I'm John Collins, and I will see you for our next edition of Crime in the Courtroom. Take care.